So we're here today to talk about another United States Supreme Court case. This was a case from 1970 called Pennsylvania versus Mims. And here's what happened in the Mims case. This was 1970, it was Philadelphia, and a driver, Mr. Mims, was pulled over for a tag violation. No allegation that he was driving recklessly or erratically or that he had done anything else to commit any crimes. It was simply a technical tag violation. When the officer pulled him over, the officer demanded that he get out of his vehicle. The driver got out of his vehicle, he produced his license and registration. When he did so, the officer noticed a bulge in his clothing. They searched him, and on his clothing was a firearm. He got charged with the unlawful possession of a firearm, and he was convicted of that offense. At trial, his counsel argued that there was an unlawful search and seizure when law enforcement ordered him out of his vehicle in the scenario of a simple tag violation. That was reversed in the High Court of Pennsylvania, and the state of Pennsylvania appealed that to the United States Supreme Court. The government's argument in this Pennsylvania versus Mims decision was that the ordering of Mr. Mims out of the vehicle was a lawful use of police authority, and it was designed to protect law enforcement on the streets. In a split decision, 4-3, so 4 Supreme Court justices voted one way, 3 Supreme Court justices voted the other way. In a split decision, the United States Supreme Court reversed the High Court in Pennsylvania and found that in the scenario of a lawful traffic stop, law enforcement is permitted to order a citizen out of a vehicle, even where they don't suspect that they've committed any crimes, for officer safety. So if you're stopped by the police for speeding, or if you're stopped by the police for a tag violation or running a stop sign, and they say, "Sir or ma'am, get out of the car," please get out of the car.